Can we start? Abhijeet sir, Shaurya sir.
Yeah, sure.
Abhijeet sir.
Hi. Good evening.
Okay. So, a very good evening to one and all present here. I am Ms. Urmi Sheth, welcome you all on behalf of Knowledge Teas. Started in the year 2012, Knowledge Teas has walked past several milestones since then. I think there is some interruption. Okay, yeah. Started in the year 2012, Knowledge Teas has walked past. Sorry, what is this issue? Walked past several milestones since then. Knowledge Teas attempts an effort in keeping students, researchers, scholars, academicians, and teaching fraternity updated with all the academic opportunities coming their way in order to boost their career and promote such wider information dissemination. Knowledge Tea's core aim is to provide training to students and faculties about research, human rights, and allied subjects. It has recently got itself registered as Knowledge Tea's EduHub. The session shall be addressed by our esteemed guest speakers, Advocate Abhijeet Gupta and Advocate Shaurya Krishna. Abhijeet sir is a founder and managing partner at Abhijeet Gupta and Associates. He is also panel lawyer at Haryana Power Utilities, Shikhsa Pariyojna Parishad, Haryana State Federation of Cooperative Sugar Mills Limited. Our next speaker for the evening is Shaurya sir. Sir is an alumnus of National University of Study and Research in Law, Ranchi. He is based in Delhi NCR, having a diversified practice areas of litigation, including criminal law, civil law, corporate law, real estate law, service matters, consumer laws, and more before the Hon'ble Supreme Court, Hon'ble High Courts having its judicature at Allahabad and Lucknow, district courts, and other tribunals of Delhi NCR. He is currently serving as a junior counsel for the state of Uttar Pradesh and Yamuna Expressway Industrial Development Authority before the Hon'ble Supreme Court. Additionally, he has an immense experience of handling real estate disputes before the Real Estate Regulatory Authority and has represented many real estate companies and home buyers before Rera. A very warm welcome to both of you, sir. Thank you for joining us today.
Thank you so much.
Now I would request Abhijeet sir to address the audience. Over to you, sir.
Good evening, everybody. So today we are discussing about Rera. So we'll go in details about why we need Rera, what exactly is the purpose of Rera, how the courts are dealing with the problems faced by the home buyers, and how what judgments are coming in, and how the courts are executing the orders. And in fact, most importantly, there are certain problems with this present setup of Rera. So we will be discussing them as well. And most importantly, there are certain alternative courts to Rera as well, such as NCLT, the consumer forums. So we will be discussing those as well.
Shall I speak now if I'm audible? Abhijeet sir.
Yes, sir.
Okay.
Please go.
Right. Nice to have you all here. Very good evening. And first of all, I would like to thank Knowledge Teas for organizing such a blissful event. And personally, I would like to thank Mr. Mehak Rathi ji and Sanidhya for inviting me over here. Now, as we all know that Rera, I think all of us who are into this webinar are aware of the whereabouts of Rera and the basic structure of Rera, but we'll be dealing with the intricacies of the sections. And yes, as Abhijeet sir said, the recent judgments, we'll be discussing all that. And since I started my litigation in Rera, and when I started, Rera was a little infant at that point of time, but with due course of time, the law has developed. The law is doing significantly fine, and the authorities are providing relief to the home buyers as well as the promoters as well. So I think Abhijeet sir may now continue.
Yeah, thank you so much. So Rera, so there are basically in every state, like we are having this Rera. So in a barrage of cases, Rera is doing well. So let me start with an example of, let's start with the batch of petitions that we have recently argued before Haryana Rera. So it was a case where the builder had failed to provide the possession within the stipulated time period, and there was absolutely zero construction at all. There was no construction, and in fact, a lot of financial institutions are involved as well in this particular batch of petition, which I'm talking about. So the court specifically as an interim protection, as an interim order, asked the builder to continue with the reliefs, with the promises that were made to the home buyers, such as no rent, no EMIs, the pre-EMIs which were going to the financial institutions. However, the plea taken by the financial institutions were that they are not subject to the jurisdiction of Rera because they are financial institutions. However, we successfully argued that all the banks, the financial institutions, they come under the purview of Rera by virtue of the circular of the National Housing Board, the NHRB. And therefore, they cannot say that they are not subject to the jurisdiction of Rera, and they cannot as such escape from the clutches of the law and cheat the home buyers in conjunction with the builders. Most importantly, in another case that we have argued last year, the Gurugram Rera was pleased to declare that the financial institutions are the promoters. They cannot say that we have nothing to do with the project. We just want our money coming in from the home buyers, irrespective the project is complete or not. The court was very open and very pleased to declare this, that they cannot escape from this by saying that we are just the financial institutions and we have absolutely no responsibility towards the home buyers, all in all. Over to Shaurya Krishna, if you want to add anything over here.
Yes, you have argued a very, very relevant point that home buyers are facing these days. So there is this kind of agreement, there is a kind of payment plan that builders heap you into in that subvention scheme.
Correct.
Which is very famous, which I think you must have argued in your matter as well. So in the subvention scheme, what happens is that you get the possession of that property first, and then when you start living in that property or that unit, you start paying your EMIs, and the loan disburses accordingly. So there is a tripartite agreement between the home buyer, builders, and the financial institutions. So Rera does not include the financial institution in itself in the statute. So there's a very big problem that comes here, that if the builder is unable to provide you the possession, then you keep paying the EMIs, and you cannot approach Rera and make banks a party there, or take a plea there for an interim order to stay those EMIs. So this is a very big problem, and I think this is a very good argument that Abhijeet sir has spoken.
Yes, this problem has been taken care by Haryana Rera, but when we talk about UP Rera, so they are not taking into consideration all these arguments that we have put forth. So they say that they do not think that banks should be made a party to the petition which you are filing. Yes, you want a refund, you can approach us for a refund. You want the possession, you want delay penalty charges, yes, you're free to approach us, but we cannot pass an order against the financial institutions as such. Now, there are many situations in which the home buyers are already facing difficulty. So what should they do? Like, for example, in one of my case, which is still pending for adjudication, and the bank has actually attached the property, the property which is under construction. Now, what should the home buyer do? Should he approach? Should he wait for the order of the Rera, or should he move to the consumer forum, or should he wait for the bank to initiate proceedings against him at respective tribunals such as DRT or a check bounce case against him, because the EMIs have been defaulted? Now, in such circumstances, Rera is absolutely not catering to the needs of people on multiple occasions. They are yet to understand when the home buyers are approaching this particular forum, they are approaching with a problem in hand, and that has to be addressed. Some interim relief has to be given. So this is something which yes is a problem with Rera, not just Haryana Rera, but UP Rera as well. Long dates being given, and sometimes not taking into consideration what problem is being faced by the home buyer when they are approaching the court. Shaurya, you want to add something over here?
Yes, exactly. And there are some other problems as well that Rera addresses. And there's a myth that Rera is being formulated to address only the problems of home buyers or to give them refund. Rera is not there to refund you. Rera is there to give you your rightful possession of the property. Now, what is the rightful possession of a property? Let us discuss that. You must have seen in Delhi NCR, mostly in Noida and Gurugram, there are incomplete buildings where there is a big hoarding hanging, and it says that possession soon, or it says possession started. You can see a building which is completed and it says that possession started, but what kind of possession are you giving? You offer a possession to the home buyer, and the Rera Act is silent upon the definition of proposed possession in itself. In UP Apartments Act, you cannot give possession without acquiring occupancy certificate or completion certificate from the respective authority or municipal authorities. So this is what happened in the recent judgment of Supreme Court as well, the Super Tech as well, where the Supreme Court has pronounced the demolition of 2 buildings. Now, what happened to those 2 buildings? Those 2 buildings were erected, those 2 buildings were completed, construction of those buildings were completed, but why are they being asked to be demolished? For the same reason that they have not been obtained the occupancy and completion certificate from the respective authority. And why have they not? There are several reasons by which the OC and CC, we call it OCCC in short. OCCC is not given by the authority to the builders. It can be the safety issues. It can be the dues that are not being paid by the respective builders. So this is not just a possession. There should be a rightful possession as well. And Rera, in my opinion, is very silent upon this feature.
Yeah, the act, yes, the act, yes, it is silent on what exactly is the rightful possession. In fact, to add more about the Super Tech judgment that you were talking about, the Supreme Court has specifically held that these towers shouldn't have been constructed. They are illegal per se, and they have been constructed in nexus with the Environment Clearance Board of the UP government, which shouldn't have happened, right? So this see, all this comes down to the Rera and its monitoring process, because as of now, Rera is supposed to monitor each and every project which is being constructed in its jurisdiction.
Right.
And they are supposed to publish an annual report, in fact, a quarterly report on its website. So in fact, what we have seen as a growing trend in Delhi NCR is that most of the reports are not being published, right? They are being withheld, and they are not. If they are published, they are incomplete. Many of the builders who say that they have applied for the OCs are yet to get them, and they're still putting before the court that, see, we have applied for the OC. We are not liable to refund to the buyer. Neither we are under an obligation to pay the delay penalty charges to the home buyer as well. So this is something which is, the monitoring process of Rera has been badly implemented in almost every jurisdiction, which I am looking after: Rajasthan, Haryana, UP. There's absolutely improper implementation of this process. Besides that, now the second problem which we come to is that Rera is not executing its order properly. I'm sure you must have come across this as well in the courts where you are practicing, that the orders of the Rera are not implemented. The home buyers, yes, they get the orders, but with the implementation, with the execution, there's a huge delay, right? Supposedly, if I get my client an order for refund, And if the refund is not coming for the next 2 years, 3 years, let's say, because there is no executing officer or the adjudicating officer is not looking into it, what are we supposed to do? I'm sure you must be facing some problems with your clients as well.
There are plethora of cases as such where we face such problems, and we often call Rera as a toothless tiger nowadays, because it passes its orders very efficiently in a very time-bound manner, but the execution of orders are not up to the mark at all. So you approach to the Rera under section 63 in UP. They have formulated some roles, and they have published one SOP on 2nd of September 2020, which elaborates the process of the execution of the orders of Rera, which is governed by section 63 of the Rera Act. And the SOP specifically talks about 3 kinds of orders that Rera mostly passes, apart from the interim orders, 3 main reliefs. One is to offer them the timely possession and the rightful possession on such and such date. Second order is the order of refund, in which Rera says that you have failed to complete the project in a time-bound manner and there is an inordinate delay. So the home buyer is entitled for the refund along with interest. So provide him the refund in such and such days. And the third order is the conditional order that Rera gives often. It's like give them the possession by such and such date, say, for example, say December 2021. And if you fail to give them the possession, then refund the home buyer is entitled for the refund along with the interest. So all these 3 portions of reliefs are specifically elaborated in that SOP, like what would happen for the non-compliance of each heads. So that's a good portion, but there are some things that needs to be done as well. For example, what happens is that if there is a conditional order by Rera, and Rera says that what happened with my client is that there was an order in which the Rera said, the UP Rera said that grant this home buyer a rightful possession by December 2020, and if you fail to do so, you have to refund his entire money along with the interest within 45 days of the completion of that period, like 31st of December. After 31st of December, you have to refund him with interest the whole amount. Now, what happens is that the builder did not refund any amount to us. Then we filed a separate complaint under section 63 of Rera Act. And what happened is that COVID second wave came in between, and there's a lot of time that has passed in between. And my date has come just last week. So what happened at that point of time is that the builder has completed the project. The builder has offered us the possession along with the OCCC as well. Now what Rera shall do? Can Rera reverse its own order? What about the legality of that order that has been passed by Rera? Is it null and void now? Now the Rera is saying that you take the possession, because the intention of Rera is to grant you the home to the home buyer and not the money that you have invested. But the home buyer is entitled for the refund as per that order of Rera. So Rera is talking, acting like a two-edged sword.
Yeah, that's absolutely true. So we have faced this in one of the case which was listed yesterday before the Gurgaon bench of Rera. So this is the exact same situation. The order has come for refund, and now the builder has given us the OC and the CC. Now what are we supposed to do? Shall we take the possession or shall we wait for the court to modify its order? How it is supposed to work? In fact, I would also like to throw light upon one of the case which was decided in 2018. Right. And it was a case for refund, and the execution petition has been filed late 2019, and yet my client is supposed to get his refund from the builder. So, and the dates are being given one after the other. So this is a very big problem which all of us are facing with regards to dates, the implementation of the orders, the judgment, the execution of the judgments. And yes, I'm sure a lot of people who are practicing, my friends who are there listening to us, they must be facing these problems as well.
Exactly. So I think this is Rera in a nutshell. We have talked about its beauty and the criticism as well. So every law, it's still in its growing age, I guess. With such discussions and arguments, we can make it grow better.
Right.
So same thing is happening with the IBC as well, actually, in the NCLT.
Right. Right. It's in a very Rera as of now. It's in a very infancy stage.
Yeah.
I would say that the forums are still growing. They are learning how to function properly, how to do it, because this is for the first time an act has come into force which specifically deals with the home buyers, the investors who have invested in real estate, and I'm sure the forums will get better over time. But alternatively, we have IBC, we have consumer forums, and they are dealing pretty well because they are experienced forums. NCLT specifically has been very good with the decisions, and in fact, recently just before the second wave of lockdown, two of the projects which we were arguing for the home buyers, so the builders have gone into insolvency. So yes, we are very confident that NCLT will continue to fill the void as long as there are sufficient numbers of home buyers who are approaching the forum. So over to Shaurya.
Yeah. There is one more concern. There is one more issue that I am concerned of is regarding that. There is one judgment of the Honorable Apex Court wherein the Honorable Court had said that the home buyer is free to lodge a complaint in Rera as well as file a complaint in consumer forum as well. It can go to the multiple forums. So what happens is that it becomes a forum shopping after all, and the implementation, and once the stage of arguments are completed, say the Rera has ordered a refund of, say the Rera has ordered the possession, like the home buyer is not entitled for refund, he should be given the possession. And on the second hand, the consumer court says that no, refund him accordingly. Or if the Rera says refund him with 9% interest and the consumer court says that refund him along with the interest of 24%, then which of these forums orders will prevail?
Right.
This is the very subsequent burning issue that is going to come up in the future as well. That's what my personal opinion.
Yes, this was highlighted. This was actually addressed recently in Haryana Rera, where the court said that if you want to approach us for either for refund or for possession or for the delay penalty charges, and if any other complaint is pending, let's suppose in the consumer forum, you will have to withdraw your complaint there, and then you approach us.
Correct.
If you want to continue with that one, we'll have to dismiss this case with costs because this is forum shopping.
Correct.
And this is actually happening with NCLT as well, because people are getting orders from Rera and then putting them before the NCLT as well. See, this is the order, we've got an order for refund, and that creates a impact subconsciously on the judges there as well. Let's see, this particular person has got an order for refund. Yes, there must be some problem. I'm not sure how much effect does it create, but yes, it must be having some kind of an effect that the project is not ready. The builder failed to provide the possession, and therefore the IRBs are being appointed after the orders of the NCLT as well.
So just such forum shopping is just going to create a havoc, and the only fraternity is going to be benefited by this is the fraternity of us lawyers.
Yes, we definitely do get benefit out of this, but yes, there has to be an end to this problem somehow. Let the apex court decide. Or probably this, if it is a matter of the states, then the high courts should intervene at some point of time. Because this is going to create multiple orders. This is further going to prolong the litigations for the home buyers and for the builders as well. See, as per the act, the intention of the Rera is to protect the interest and to balance the interest of both the home buyer and the builder. It cannot lean in one particular direction that we give some undue advantage to the builder or we give some undue advantage to the home buyer. So let's suppose that Rera Act now says that if the tower has been constructed to the extent of 40%, right, and the construction is in progress, we'll give some time to the builder to complete the project and then file an affidavit with us. We'll look into it and then we'll pass the appropriate orders. And now Rera has actually started taking affidavits from the builders while they're arguing that you give us an affidavit as to what is the stage of your project, how much has been completed, how much time do you need to complete this project. And in some cases, Rera is also appointing LCs, the local commissions, to monitor the construction progress as well. So yes, it should be balanced. And in fact, there's another trend which I have started noticing specifically in NCR, is that the builders are now filing cases against the home buyers who have defaulted on payments somehow, right, on the construction link plan or the subvention schemes. So this is another trend which has recently picked up.
Yes,
In fact,
correct.
post the second wave of lockdown.
In UP, Supertech had started it, and they have filed some complaints against the home buyers as well, because they often take that section 32A of Rera Act, which states the promotion of all the three stakeholders of real estate industry, that's home buyers, promoters, and real estate agents. So they all have specific functions and duties allotted under the ambit of this act, and they all are they are all able to file a complaint against each other. There's no specific bar upon the builders that they cannot file complaint under Rera.
Now this is again, to add more to this. Now again, this will go on to increase the number of cases before the courts, and hence longer time to adjudicate and pass the orders. In fact, as a matter of record, in Haryana, before the adjudicating officer, we have approximately 9,000 cases which are pending for the decision. So we can imagine how much time will it take for the court to decide them finally.
Correct.
And last but not least, I want to address something about the prospectus, the builder-buyer agreement, which are signed, and other promotional materials which are floated by the builder. So it is often seen that the builders are putting out advertisements, notices, images and whatnot, promising so and so things, that no EMI till possession, no subvention schemes, and rent-free accommodations and whatnot. But how many of them actually get translated to real life situations for the home buyers? How much is the home buyer able to draw out of these advertisements and all? This is all covered under section 12 of the Rera Act, where any advertisement or any promotional material or a flyer, if created by the builder for passing on to the benefit or to get bookings into one particular project, these are all considered to be binding upon the builder. If the builder says that you're not supposed to pay any EMI till the possession in one of its promotional flyer or something like that, yes, by virtue of section 12, the builder is supposed to honor it, irrespective of if the flat's construction is going on or not. So this also we've argued successfully in one of our recent cases. So this was again a batch of petitions. The builder backtracked from its commitment, and then we successfully argued and got interim orders. And luckily for us, the builder is now settling all those cases for the home buyers by providing them refund because the construction is incomplete. And the cases have been referred to the mediation center as well at Rera.
Yes, sir. I think, Abhijeet, sir, we should go for the question and answer session.
Yeah, absolutely.
We have a possibility of discussion over there as well.
Yes, sir. So may I start asking? Like, the participants have posted their questions already. Okay, so the first question is, what are the steps involved in buying a land, and how can we protect ourselves from the malpractices at each step?
Sorry, you were not clear. Can you repeat your question, please?
Okay. Am I audible now?
Yes. Please speak.
Okay. What are the steps involved in buying a land, and how can we protect ourselves from the malpractices at each step?
Shaurya, you want to answer?
Sir, please.
No, you
answer.
Yeah, you please answer. I will add on. Yeah.
So, okay. So now, first question comes is that where do you want to buy a land? You want to buy a land which is governed, which is being constructed and developed by a promoter which is registered under Rera or not. It is always advisable to purchase a land from the builder which is registered under Rera. And if the builder is not registered, the promoter is not registered under Rera, then you can probably file a complaint with Rera that he is developing such society, such and such project, which comes under the norms of Section 4 of UP Rera Act or the Rera Act in general. And he's not complying accordingly, and he's not registering itself with Rera so that it can maintain the transparency and the proficiency of the construction and development quality as well. So the first step that you should always see is that whether the project is registered under Rera or not. Secondly, if it is not registered in Rera, then you should definitely, as a responsible citizen, should file a complaint against the builder at Rera.
And most importantly, to add on over here is that whenever you're buying a house or a flat for yourself, just read into the terms and conditions of the BBA, because that is where the builder traps the home buyer. What are the terms when you get the possession, and how long it is going to take, and check the website of the builder about the Rera registration number, then verify it on the portal, Rera portal, because it is a very easy website to browse. Not much is hidden over and there. So you should just check about the status and the report if there is any about the particular project.
Next question is, how does Rera work for civilians when they want to file a complaint?
For a civil,
How does Rera work for civilians when they want to file a complaint?
for a civilian when it wants to file a complaint.
Yeah.
Civilian.
Yes.
Okay.
Okay.
There is this section 31 of Rera Act that specifically talks about the complaints and the procedure of complaint and the manner of which it can be filed. And in UP Rera, it is absolutely online. And the adjudication of Rera is also good. It does not require, and you do not have to have an advocate in, before the Rera. You can adjudicate, you can litigate and represent yourself before the Rera. And it's maintainable under section 31 of Rera.
Correctly.
So, Abhijeet, sir, you want to?
Yeah, correctly stated by my friend that in UP Rera is absolutely online, but slightly different for Haryana and Rajasthan, where you need to have a lawyer at the stages of argument, and the process is, yes, very simple. The forms for filing the complaint are given on the website. You can fill in the particulars, attach your relevant documents, your BBA, TPA, if there's any, the payment receipts, account statements, and you just need to go to the registry and file it. The process is very simple over here as well.
Demand letters from
demand letters, yes. There's like a loan account statement and the account.
If there is any kind of communication between you or buyer, you should inform to the adjudicating authority.
Next question is, what certifications are necessary to become a Rera expert or property dispute expert? What would your suggestions be to the law students who want to pursue these disputes?
This is a very budding field, I guess, Abhijeet, sir.
Yeah.
And not the only field. I mean, if I have to explain it to a law student, I would suggest that real estate law is not much diverse. You know, for starting, it's very good to open up in front of the court. Like I did, I started my practice before the Rera itself. So it gave me a kind of, it boosted my confidence to appear in any kind of court. So it's like any other forum, and it should not be a particular forum to practice law. Am I audible?
Yeah, absolutely.
Yes, sir. Okay. So next question is, what is the role of Consumer Protection Act towards the problems of real estate? There have been numerous discussions regarding overlapping of reliefs under Consumer Protection Act and Rera.
So to answer this question, if you want to approach any of the consumer forums based upon the jurisdiction, so you will have to be a genuine home buyer. So these are based on the judgment of the Apex Court that if you have invested in the property for yourself, for your family, then yes, you are a genuine consumer and you fall into the definition of the consumer. But if you're buying 5 properties, 6 properties for the purpose of investments, you're not a genuine investor. You are not a genuine consumer. You're an investor, and you're not allowed to approach the consumer forum as such in those cases. Yeah. And yes, there has been a conflict between Rera and the consumer forums, but the Punjab and Haryana High Court recently upheld that you can file parallel complaints in both the consumer forum and Rera as well. And it again, it gives rise to the dispute which Shaurya was mentioning earlier, that it opens a door. It opens a Pandora box as to which court will decide what and at what stage.
What is the tentative deadline for the procedure of recovery under Section 40 of the Rera Act 2016?
I think this is the most important question that a home buyer should ask after being aggrieved from the orders of Rera. So may I explain? May I explain the procedure if you want? So what happens is that when such order is passed by the Rera, then you expect a builder to comply with certain order. Then what generally happens is that builders shun away from their responsibilities of complying the orders and they do not comply it as such. Then you file the execution petition, then execution petition is decided, and then one recovery challan is issued from Rera. The recovery challan includes your principal amount as well as the interest that has been made till the date of that recovery challan. From the date you have paid your money. So what happens is that recovery challan goes to the district collector, the district administration of a particular district, and then it becomes the responsibility of that district collector to collect such and such amount from the promoter. So there is no such timeline, specific timeline is not given in Rera as such. So you want to add?
Yeah, I want to add something over here that yes, there is no timeline as such given in the act itself, and the execution process is the one which actually gets delayed all the time, because in certain cases it has been observed that nobody is appearing for the builders, and when they do appear only when the properties are being attached, their Rera bank accounts are being attached, or the arrest warrants are issued by the Rera. Even then, the builders have not shied from challenging the calculations put in the execution petitions by the home buyers that the amount calculated is wrong. This receipt, we have never issued this receipt. This also had started popping up that we have not issued this receipt. This is not ours. And then the statement has to be tallied by the chartered accountant appointed by Rera, and then it ultimately gets delayed. So. And moreover, to add this, the district collector, and by attachment of the properties and by the auctioning, whenever he recovers the dues, so then only the amount can be paid to the home buyer actually. So this actually has become a big problem for the home buyers to get the order successfully executed. The obtaining the order, you can get it in 2 dates, 3 dates at most. But then when it comes to the execution, there's no fixed timeline for that. It can take 6 months. It can take a couple of years, it can take 3 years, and it can go on forever, because as long as the recovery is not being affected by the district collector, there's absolutely no implementation of the order of the Rera.
I mean, once the recovery challan is issued from the Rera, the responsibility of Rera is done from that end. Right. And then it is the onus lies upon the shoulders of the district administration to get your money back, and it follows certain state land areas, which is a matter of respective states. It follows certain state land areas.
How do you see Rera changing the landscape of real estate in India in near future?
It's a very subjective question, I guess. Abhijeet, sir, you want to proceed? Please initiate.
Yeah, so see, Rera was implemented with the purpose that the disputes faced by the home buyers will be resolved on a priority basis. So these tribunals were created for that specific purpose only. And in the last 3 years or so, after the Rera Act has come into existence, we have seen that the disputes are being resolved, right? Still slightly better than what used to happen earlier in the consumer forums, and it will definitely change the landscape in future, because there are many compliances which have to be done, right? Before you obtain the OC, before you obtain your Rera registration number, you ought to have a Rera monitored bank account, right? There are a couple of changes. There are so many changes which have taken place, and in the future, yes, with Rera growing and coming out of the infancy stage, and with people learning more about Rera and its outreach, growing, we see that these problems will be resolved a lot quicker than they are being done today. Over to Shaurya.
I think it has already changed the landscape, and from the past 3-4 years, now the home buyers at least know a particular way where to go. Otherwise, it was a very difficult and challenging task for a home buyer to decide which court to approach and what strategy shall it take to recover its amounts from the builder or to get the rightful possession. So Rera has significantly improved the stature of real estate in India. But there are many loopholes that still needs to be filled, and I sincerely hope that with due time, those holes will be filled and we can have a smoother path to justice.
Yeah, absolutely. And in fact, to add more over here, I'm sure a lot of people must have listened to all these advertisements on FM and in newspapers and on social media as well. Now everybody has starting mentioning their Rera numbers. In
Rera.
fact, yeah, absolutely. So this has not earlier. Nobody used to talk about what kind of registration they have. What do they have, actually have the land, or are they just doing just like that? But now, yes, with all these changes coming into the picture, with this act being in place, we believe that the situation will improve in future. Like it has already started improving, and going forward, we see a lot of things will change, especially for the home buyers and their interest.
Parking is not saleable, but builders are charging for the parking. Can we go for this in Rera? Like, can we file complaint for the same under Rera?
I think open parking cannot be charged, but the covered parking they still can include in the open area. They still can include in the common area, I think.
Right. So if you get an open parking, if it's, I mean, like if your parking is not charged for your in your BBA, you can approach the Rera. If they're charging for it later, yes, you're very you can go to the court and just mention your problem that this is being faced by us. This was not in the BBA, and we want to challenge this now because the builder is asking for money for the parking, which was supposed to be free.
Will Rera bill make builders more accountable?
Sorry, I didn't get it.
Will Rera bill make builders more accountable?
Yes, it has. Even it has made some builders accountable, and it has also deregistered some of its projects as well because of the lack of accountability that they hadn't shown to the Rera. Rera acts, at least it puts a sense of fear in the minds of this promoter lobby. Yes, it has made accountable these promoters.
And because the biggest fear is that the registration will be cancelled, and then Rera suo motu itself will start a complaint proceeding against the builder if the project is not, if the compliances are not being done. So yes, it has instilled a sense of fear in the builders, and yes, the lobby as well.
And the sense of fear also brings competitiveness and accuracy in that work as well, in their work as well. So you see, earlier it was just like any project would be like Birbal ki khichdi. So it keeps going on. But since the advent of Rera, it has stopped at least.
What if the regulatory authority does not respond to the complaint? Am I audible, sir?
Yeah.
Yes, please repeat your question.
Okay. What if the regulatory authority does not respond?
No, they do respond. It never happens. You will always get a complaint number registered whenever you file a complaint, and they do respond in a very timely manner. And the adjudicating process goes on. It never happened. Like if you paid for you also pay a government fees for that. And you get a receipt of that fee, so they cannot escape their liability.
So yes, he's very right that it seldomly happens that the complaint is not catered to. The court registry is actually under an obligation to put the case for hearing, irrespective if the complaint is maintainable or not maintainable. Yeah. It can never happen that you complain.
So the functions. So this comes under the functions of Rera, and that those functions are mentioned in Section 32 of Rera itself. So they have to comply with that.
It might happen that there are certain defects in your complaint which you have filed, but once you cure it, the petition might be taken up.
Yeah.
Will Rera bill make the process of getting a home easier?
It has made the process a whole lot easier, to be very honest.
Correct.
You can actually check the status of the project, the construction, and basically everything is there So this act has brought transparency to some extent.
Transparency is the key word that Rera highlights in itself. That you correctly know the correct status of your project, of your unit. And it has only happened because Rera is there to beat them up.
Are the civil courts and consumer forums barred from entertaining disputes under the Act?
Under this act, only the adjudicating officer or the authority can take up the matters. So if you want to approach the civil court, you will have to file a separate civil recovery suit against the builder, or if you want to go to the consumer forum, that itself is a separate proceeding. It cannot be clubbed under this act, at least.
Yeah. And if you go to the civil court, you have to pay the suit fees as well. So your suit fees also get protects if you file a complaint before the Rera.
What happens if the builder delays the possession?
Sorry, what?
What happens if the builder delays the possession?
What happens when builder delays the possession? So there are, as I told you, there are three main reliefs in Rera that you may see. One is when you want the possession of your property as soon as possible. Second is the conditional relief, that if the possession is not given to us, then the builder shall refund our money with interest. And the third is the refund as well. These are the three basic heads of relief that we have. And
yeah. So to add more to this, there's a fixed timeline which is given in your BBA. So the BBA will clearly state that the project will be completed in 36 months or 42 months plus some grace period. Yeah, plus some grace period. So if the project is not completed within that period of time, you can approach the authority, say that we want money back because the project has not been completed, or you can ask that we should be given the delay penalty charges until the possession is actually given. So these reliefs are actually being given on a daily basis to many of the home buyers.
Is Rera approval mandatory for plots?
That depends upon what is the area of that plot and how they are going to develop it and construct it, and if they are going to market it for the commercial purpose or not. Because it's specifically, there are certain provisions that are briefly discussed under Section 4 of Rera Act. So 3 and 4, wherein you can see that the project should be registered under Rera or not.
Sir, could you once again brief us about the facts and the super tech case judgment, and what are your opinions on the same?
I think it's a very, very big deterrence upon the whole bidder lobby, and the judgment is acting as a nightmare for the promoters these days.
Yeah, I want to add something over here. So I was reading in the news today that all the 3 directors of Supertech have fled. They're non-traceable at the moment after this judgment.
Okay.
There is a sense of fear as well, because you see the Twin Towers had been, they were constructed much before the advent of Rera. They were completed in 2014, I guess, 13 or 14. And the sanction plan was approved by the Noida authority then at 2005 or 2006. So the builders did not comply with that, with the layout provisions, with the safety provisions, and there were some provisions of UP Industrial Dispute Act and Urban Development Acts. So there were many compliances that the builder had not fulfilled, and as a result of it, the demolition is being directed.
And that too at their own cost.
That too at their own cost. But the problem is that the implementation of this order, now you just imagine the project is ready. There is so much cost involved upon building the project, and now you have to demolish it. Now demolition cost will also incur, the demolition cost will be in crores. It's located in a very civilized society, 93A of Noida. So you cannot just plant a bomb inside and
just bring the tower down. It cannot happen just like that. So there will be a huge cost that will come attached with this demolition. And consider from the point of view of the builder that every home buyer was booked a unit in these two towers has to be refunded along with interest within 2 months. It's a big implication actually, and this should actually instill a sense of fear in the builders that you can do whatever you want to. Right? Either the courts are there watching for the home buyers and their interests. So,
and my personal opinion is that there is not just this super tech which is involved in such discrepancy. There is some involvement of the authority as well. Without the sanction, without the approval of authority, how can they make 40-story buildings, 240-story buildings?
correct.
But the judgment was silent upon the discrepancies that have been committed by the officers of the Noida authority, who were then posted at that point of time, who had given all the approvals. The judgment is silent upon that.
So that's all the questions we had for today, sir. Thank you so much for such a wonderful session. Basically, once we were not aware of the basics of Rera and we did not know more about it, but now we have at least a brief about how does it work and what are certain advantages and disadvantages and how do we go about it.
Thank you so much. I hope we have concluded within time.
Yeah, absolutely.
Yes, sir. Yes, sir. Thank you.
Thanks to the team and thanks Urmi for being such a wonderful moderator. All the very best. And thank you for all the listeners.
Yeah, big thanks to the team for organizing this webinar. I think we have at least imparted some basic information about Rera. But before we sign out, so it is very important that any home buyer or you, if you are an investor buying a commercial property, it is you who has to take care, who has to be diligent before investing or buying any particular project. So it is your wisdom based upon what documentation is being done, what is there in the BBA, what is there in the TPA, right? How are the banks going to trap you at a later stage, right?
Correct.
Whether you give PTCs to the bank for safety purposes, right, or whether you are giving an ECS mandate. So these are something, some of the things which you have to take into consideration before you, finally seal the deal, right? So I'm sure we have done some of it, and let's hope that we continue to do even better for our clients. And I'm sure a lot of people here will be starting with their practices. So yes, this is an absolute perfect forum to start. You can just start learning just the basics, get your basics right, and you're good to go.
Yes, sir, that was very enlightening and insightful session for us. And thank you so much once again for sparing some time from your busy schedule, like that too on Sunday.
Thank you so much.
Thank you so much to you and the entire team for organizing this.
Yes, thanks again. Thanks, Abhijeet sir, for being.
Thank you so much, Shaurya, for being such a wonderful speaker. Good. It was really a pleasure.
It's been a pleasure. Okay, sir. Okay. Thank you so much.
Thank you, Shaurya, sir.
Thank you to all the participants for being cooperative and patient. Stay safe, everyone.
Thank you.
Thank you, sir.